Guys, welcome. What is today? The 13th of June, another Hot Topic Tuesday. This is our deep dive with one of the best in the state of Michigan for real estate attorney practices. Very knowledgeable, great teacher, which is the reason that I had him in to here in Rochester. And we just had some great conversation that we probably could have kept going for about an hour and a half, 2 hours with a little bit of Q&A and so on. So Rick, with that, I don't know if you've got an introduction. I kind of sent you a few questions. I know one of the things that I think would be great if we could start out with is that Ladybird deed, as it's been come to know as, and then we've got other questions that we'll throw at you.
Absolutely. Thank you for the opportunity. I assume, Darwin, that the format will be the same, which is if someone has a question, they're free to ask it at any time. Hopefully it's real estate related, maybe even more hopeful it's somewhat related to what we're talking about, but it doesn't have to be. If it's real estate related, I'm happy to take that question at any time and or follow-up questions. If not, you're going to be stuck with me just talking, and that might get a little boring. So with that, I will start with Ladybird deeds. So a Ladybird deed is, and it's commonly referred to as a Ladybird deed after Lady Bird Johnson, the president's wife. As a technical matter, it is known as an enhanced life estate deed. What does that mean? Well, let's start with what the purpose of a Ladybird deed is. The purpose of a Ladybird deed is to avoid probate. A Ladybird deed can be used in conjunction with a trust. It could serve the same purpose as a trust. In other words, you might only need one or the other from an estate planning standpoint. How does one know? Well, it depends on that particular person or person's facts, their situation. Let's go to the deed itself. So the deed itself, it is typically in the form of a quitclaim deed. The grantor is the owner of the property and wants to remain the owner of the property. So we'll say it's me. I have a piece of property that I own, and I want to retain my rights to this piece of property. But if I'm not here for whatever particular reason, most notably I die, then I want the property to go to my wife or my 5 children. The Ladybird deed allows me to retain a present life estate. So I retain the ownership. And as part of retaining the ownership, I retain the right to occupy. I retain the right to mortgage. I retain the right to modify the property. I retain the right to rent it to someone else. But if I die, I have named a party, could be a company, could be an individual. I may have named multiple individuals. I may have named multiple companies like charities, but could be just a regular company. I may have named a combination of my children and a charity, etc. Those people that I've identified, they have what's known as a contingent remainder interest. In plain English, that means that if I die and I still own the property, they get it. If before I die, I sell it, they don't get anything. The contingent part is it's contingent upon me passing. What is significant about a Ladybird deed versus other deeds that may be used to avoid probate is that all of the power remains vested in the current owner. So I see this many times where mom will deed her adult children onto the property with her because she wants to make sure that in the event she passes away, that her children end up with the property. And she either doesn't want to pay for estate planning I think most people, if they talked about it, would understand it's not really that expensive, especially for what you get. But sometimes there's just a general apprehension, this is just easier. I get what deeds are, and I'm just gonna sign a deed, and from me to myself and my two children, because I saw that on the internet. Problem is that conveyance, that deed can have unforeseen consequences. For instance, my adult child is married, but now gets divorced. And their soon-to-be ex-spouse makes a claim in the divorce that this is an asset of my son. And therefore, the divorcing spouse is entitled to some of it. Now, I would tell you that in court, it can be proven that this was done for estate planning. It's not really an asset of my child. And therefore, the divorcing spouse isn't going to get any of it. And I'd be confident I'd win that. But you're in court. You're explaining that. My adult child files bankruptcy. I need to explain that this isn't really an asset for purposes of bankruptcy. My adult child, unfortunately, is at a bar and drinks and crashes their car and hurts somebody. And they sue and they say this is an asset. I'm confident in all those scenarios that an attorney could establish that this was done for estate planning purposes. And again, I'm talking about just a regular old quitclaim deed from myself to myself and my kids. The problem is I have to prove it. And even though I'm confident, I can't guarantee it. And more importantly, you're paying somebody to prove it. If you use a ladybird deed, you get all the benefits that people are trying to achieve, which is that upon their demise, the asset goes to somebody that they care about, that it's intended for. It avoids probate. But while that grantor is alive, so while I'm alive, I retain all power and control. So if my adult child gets divorced, if my adult child files bankruptcy, if my adult, pick anything you want, any of the heirs, nothing happens to me. I'm the current owner. In addition, I've had these situations. Mom says, we'll keep using me. I say, okay, I want to go to my kids. And a year later, I want to refinance the house. Well, my kids have to sign. Well, in that year span, one of my children and I are no longer seeing eye to eye. And they say, well, I'm not going to sign. So, well, you have to. Well, my child says, I'm not going to sign, Dad. I'm frustrated about, that you said I was your favorite child and then you switched from me to my sister. And I'm not going to sign. Well, at that point, I cannot refinance the house. And someone will say, and I've had this question, well, Rick, you're telling me that's it? Like I'm stuck? Say, well, you could take your kid to court. Say, Rick, I'd rather do nothing than take my own child to court. I said, I get it. You're stuck. If you use a ladybird deed, none of that occurs. Your child or whomever you name, they are contingent. They have no present interest. Therefore, their assent or requirement or cooperation or anything you want to call it is not necessary. It is unneeded. And that's the big upside of a ladybird deed. In addition, you can change the heirs. So I have 5 children and one of them really irritates me this evening. Tomorrow, I decide to take, it's only 4 now. And then the next day, another one irritates me, it's down to 3. And the next day they irritate me, it's down to 2. And then one gets in my good graces and I make it back to 3. Now, I'm not really suggesting that because it takes a little bit of money and effort to do all that. But the point is, as your life changes, you may change who you want to receive the asset. Maybe as you get older, you want a grandchild. Maybe you worship at a particular church and that changes. And now it's a different church. So you have the freedom to change who the beneficiaries are, in addition to, of course, being able to sell it at any time. And that, to me, is what makes a ladybird deed so appealing to anyone that has a concern about what happens to their estate upon their passing. I am getting a question. Should I be taking these questions directly, Darwin, or
I'll tell you what, yeah, and I've got a few extras, so we'll hit them as they come through, but as long as we're on the topic, to clarify then, I think for anybody who remembers back to their pre-license training course, really what we're talking about in simplest terms, a ladybird deed is simply life estate in our simplest terms. Am I right on that?
I would use, yeah, I would say life estate. It's a life estate deed with a contingent remainder interest, which just means you're not giving anything away currently.
And so with that, it just gives that justification when people start talking about how should I hold title, or I'm getting up there in my age, what should I do? It really shouldn't be us who gives them any guidance or direction, but rather this really justifies why we should be turning them over to a Rick Linnell. Is that
Yes.
a fair statement?
Yes, I appreciate that. But yes, myself or some other attorney. And the reason is that, and I don't know if we'll make it to it in this conversation, but forms of ownership is something that most people don't fully appreciate, don't understand. In fact, I'd say don't understand at all. And even some real estate, seasoned real estate professionals don't always know all the nuances of the 4 forms of ownership that our state has to offer. And even if the real estate professional knows, and there are many that know them very, very well, you still have to apply the facts of a particular situation to the various forms of ownership. And again, not that a real estate professional couldn't do it or isn't capable of doing it, but I would argue that it's outside of the scope of services that a licensed real estate professional offers and outside of the protection that errors and omissions insurance provides.
Awesome, awesome. So guys, any other questions out there, maybe right around this? I got one here that's around this subject matter. Rick, what about, this is an interesting twist. What if I have the ladybird deed and I went out and did a reverse mortgage on the property?
So you could do a reverse mortgage on the property just like any mortgage. And it would effectively negate the contingent remainder interest at that time. Now, I say effectively because technically it doesn't, because even if you have a reverse mortgage, you can pay it off, and that might happen, during your lifetime. So it's not an automatic undoing, if you will, of the contingent remainder interest. But let's say it puts it in significant jeopardy. And as the grantor, you have every right to do that. That's really, again, the big point is you've given up no rights, none, not a single right. And that's what's so critical, because we find many situations where people are intending to sort of do that, but they don't know the nuances. They just looked at the internet or somebody whispered in their ear, hey, you should deed your kids on with joint tenants with full rights of survivorship. And if we get into it, I'll give you some of the disasters that we've seen, the outcomes that could have easily been avoided had somebody understood what they were trying, articulated to somebody, here's what I want to do. And somebody said, okay, tell me the details. And the disasters we've seen could have easily been avoided, most often by a ladybird deed.
And often I think, I'm thinking about, Rick, estate planning. I've got a mother-in-law that's 83 years old, and a few years back, they put everything into a trust. I believe the living trust is what it's called, versus my parents, where we didn't do anything. And essentially is what was left. There was nothing left because of adult care, call it the nursing homes in the state of Michigan put a $342,000 lien on a $100,000 property. So it was one where there was literally just nothing to do because estate planning was not done. And I just clearly, I guess, what would be the message be to someone who's saying, I want to make sure I'm taking care of my children for my passing?
Well, they should speak to an estate planning attorney. We do it, but so do many other attorneys. you want to speak to somebody about your concerns and your particular fact pattern. I can't tell you that everyone needs estate planning. That's not true. Now, most people, if you said, well, what do you want to happen to your house when you pass away? And they say, well, I don't care, I'm not married. Okay. Do you have any children? No, I don't have any children. Do you have any relatives? None that I like. You know, what I only care about my dog. Okay, would you like to leave this to the Humane Society or the care of your dog? You know, in other words, most people have something that they care about that they would want their property to go to rather than the state. Most people don't really want the state to get their assets. And it's nothing more than a conversation. And somebody might go away and say, I don't need anything. I don't want anything. Not everybody needs a trust. It depends on what the particular person's situation is and what they're trying to achieve. But I think it is well worth doing because as most of us know, usually there's somebody you care about, an organization, a charity, a friend, a relative, or something that you care about. And obviously nobody wants to leave this planet any earlier than they have to, but when it happens to all of us, we'd like to know that our assets went to something we care about.
I just wanted to mute as the fire truck went blowing by us. So, well, let's shift gears because this is one that prior to joining onto the session today, I was just discussing a little bit about foreclosures, in particular tax foreclosures. So Scott, Sally, if I'm in the wrong direction, let me know. But I think this is a great one. If I pick up property through a tax sale or tax foreclosure, how do I clear up the title, or how do I know what are the steps I should take to be able to get that? There we go. So what steps should I take if I am one who's going to acquire property through a tax sale?
So the first thing I would do is I would take my deed to a very reputable title company. Do you guys know any reputable title companies? I bet you do. So that's where I would take my deed. And what you want to find out from the title company is a quiet title necessary? Will you write title insurance based on this deed? And the title insurer will look at the deed. They will typically request a FOIA, or which is a Freedom of Information Act request that they will make to the treasurer that shows what efforts were made as part of the tax foreclosure. They'll want to review it. Notices is the big thing they're focused on. And the title company will tell you, you need a quiet title action, or you do not need a quiet title action. The title company is effectively the gatekeeper, and which I actually think is great because when you sell, you're going to want to be able to provide title insurance to your purchaser to get retail or highest and best value. So, and that's the simple answer is you take it to the title company. Now, if the title company says, look, you are going to need a quiet title action. A quiet title action is a lawsuit filed in circuit court, and it is effectively a request to a judge that they recognize that your title insurance, strike that, your title, your ownership interest is superior, generally speaking, to everyone else's. So a quiet title action that is filed as a result of a tax sale would include as defendants anybody with a prior interest, like the prior owner, like a prior mortgagee, for instance. There may be other liens that existed on the property, and all of them would be named in this lawsuit. Typically, the named defendants do not respond. It is unusual that they respond when title was taken as a result of a tax sale. Typically, they are defaulted, which means that you demonstrate to the court that you have made proper notice, specifically service of the lawsuit, and there's been no response. There are court rules as to how quickly responses have to be filed. And once those periods of time have elapsed, then the court will give you a judgment. That judgment is certified. It is presented to the title company. It is recorded in the chain of title, and it acts like a warranty deed. I'm not going to call it a warranty deed, but it acts like a warranty deed because a court has recognized that the plaintiff, the owner of the property, recognizes that they have full, valid, marketable title. There are times when it's contended, when there's somebody in opposition, but that is unusual in a tax sale. From a cost standpoint, I would estimate $2,000. That would be all in. That is your court filing fees. There are usually additional processing fees for alternate service. We have done, I think, 600. I think we're in the 600s right now. And we do other versions, but the most common version is from the tax sale. But again, your title company will tell you if you need to get the quiet title action. And if they say you don't, then you don't have to spend a penny and you are good to go.
So let's shift gears. I had some that were sent to me in advance. And I think this is one that everybody would like to hear about, but let's see. Question is the seller obligated to allow any type of inspector into their home during a buyer's home inspection period? As an example, they gave us, I sold a home and they did a home inspection. They then sent their roofer to give a better look at the roof. They didn't like the roofer, so they're now asking for another roofer to come. Seller's getting annoyed with all this. Does he legally have to allow anyone and everyone in multiple times over the inspection period?
Well, I'm going to give you a true attorney answer. It depends.
I'm sitting here reading and going, well, I know what I'm going to ask for first.
So the inspection clause that is contained in most purchase agreements says that the buyer has the right to inspect the premises. And it's usually relatively expansive as to what they can inspect, not expect. So I would say that if let's say the inspection allows for 10 days, if the buyer brings in a traditional home inspector on day 2, and that home inspector says, you should look at the roof. And the buyer says, well, I want to bring an inspector in specifically for the roof. And they want to come in on day 5. And that inspector comes in and then they say, well, this inspector thinks there might be some structural issues. So I want to bring a structural engineer in and I want to bring him on day 9. I would tell you as an attorney that the seller, it was contemplated that inspection would happen. Now someone could say, no, it's inspection, Rick, not inspections with an S. And I'd say, if you went to court, so you said, no, I'm not going to allow, the roof inspection or the structural inspection. Buyer goes to court and says, I want specific performance. Court, I want you to make the seller let me inspect. I think that the buyer wins. I think that the court says an inspection was contemplated. This is not unusual that they'd want a structural inspection, especially because their roofer said it. And it's not unusual they want a roofing inspection because their home inspector said it. And therefore, they're allowed these inspections. Now, this presumes that they're not damaging the home in any way. But if that were to be the case, it's my opinion that a court would state that, yes, the contract allows for it. I know it doesn't state that in detail, but it allows for it. Now, if you are a seller and you say, well, then I want to write in additional language that says that you're allowed 1 inspection and it can only happen no more than 2 hours and et cetera, you could do that. Do I think that's in your favor? I don't list and sell real estate, but I mean, to me, as a seller, I want the buyer within reason to inspect the house up one side and down the other, because that, as I understand it, is the most common reason, maybe coupled with financing, but that's the most common reason deals fall apart. So if there's going to be an issue, if you're going to have a problem, find out now. And of course, what I'm hoping is you're not going to find an issue or not an issue that's significant enough to stop you. And now you're going to be kind of emotionally married to the deal. But again, to the question itself, to me, you're allowed those inspections. Now, if we change the fact pattern, we say, okay, I got my inspection on the 9th day. And my inspector said I should get a roofing inspector, and I can't get a roofing inspector until the 11th day. But 10 days is when my inspection ends. If you are a seller, you can deny access for purposes of inspection after the 10th day. You could say, look, you got to make your decision during the 10 days. And maybe in this current market, maybe that's a strategy a seller might use because of the limited demand. But under those circumstances, the answer is you can say no, but that's because you're outside the inspection period, not because of the nature of the inspection itself.
And I think that brings up, I think any of our managers are going to ask for right up front is, I need to see the paperwork. Bring me the purchase agreement. We need to know what it says so that we know what can be, what cannot be. So it really will be tied to that particular purpose. So it kind of leads us into another direction with the home inspection. Matter of fact, I'll just throw it this way, and it might be the same answer, Rick, but when a deal dies over a home inspection issue, is the listing agent required to tell the new buyer why the deal died, or can we make any reason up? Are we required as the listing agent to tell any other agent or buyer why the previous deal died?
So, ethics requires that all licensees have a duty of honesty to all, period. So you can't lie. And I'm not sure that's really what was being suggested. I mean, I read the question, but I think the person was just sort of talking. Do you have a duty to disclose why it fell apart? No. But if you're asked, why did the other deal fall apart? You cannot lie. But you do not have to disclose the reason if you're being asked.
And what you're saying then is, don't lie to them, but I don't have to tell you why.
Correct. Now, if you're being pressed hard and you've been instructed by your client, do not disclose this. And the other side saying, but I don't understand. Why did the deal fall apart? You mean, why won't you tell me? Was it a failed inspection? You say, I'm not at liberty to say. I'm not authorized to respond. I can't respond to that. Those are all true statements. Presumably, if you're the buyer's agent, you might say, boy, I bet it's a failed inspection. But, a failed inspection to me is really sort of an open-ended subjective term. A failed inspection could be because somebody found another home they like. Somebody thinks that maybe they're not going to get a bonus this year and they're not so comfortable spending that amount of money. Somebody decides that they don't want to live in a house with a septic system, even though it's functioning just fine. Somebody decides, a failed inspection is sort of a very open-ended term. Now, if the failed inspection is due to a septic system that doesn't work, if that wasn't disclosed in a seller disclosure statement, then that should now be disclosed. So buyer number 2 will have the benefit of seeing a seller disclosure statement that will be revised if appropriate. Just because, I want to be clear, just because somebody says, well, my inspector thinks that, structurally, there are concerns about the house. Well, that doesn't mean that a buyer now has to amend their seller disclosure statement to say, well, an inspector said they have concerns structurally about the house. Now, if the buyer number 1 has an inspection of the septic system and it comes back, septic system is failing, well, that's not so subjective. That's kind of pointed. If it comes from a septic inspector, as a seller, I'm going to seriously think about disclosing or getting my own inspection if I don't believe that, because now you're faced with more concrete evidence. So,
and Rick, just to jump on that real quick, if I'm in Macomb Township, does it matter? Because at that point, I had to have an approved inspector for that because it's in Macomb County.
correct.
It probably wouldn't matter for me to go get my own inspector at that point.
Correct. And that many times the health department has set inspectors that are not aligned with anybody, and they just give their opinion. So in that sense, if I were a seller presented with that inspection, I wouldn't say it's 100%, but let's say it's something very close to, what you're being presented with is not an attempt to renegotiate you. It's facts from an independent inspector who doesn't have, a vested interest.
So that let's stay right on this, because actually I've got one that was a pre-written question, another one that's come in. Let's go to the aspect of a damage deposit. I know when you were here in Rochester, we addressed this a little bit. But is there better legal language we should be using for these other than seller and purchase agree to escrow $5,000 for post-closing occupancy damage? I think in another term, it is one, what's your thoughts on damage deposits? And, should we have something different for, should they even be on a purchase agreement?
Well, so there's a lot of questions there to unpack.
Yes.
First of all, I like the use of damage deposit. It's not a security deposit. There is no landlord-tenant relationship created when a seller has post-closing occupancy. And this maybe is an overall statement. I was going to answer it when we addressed escalation clause, but here's a perfect time. It is my opinion that when an addendum is written, that it needs to be thorough. And this sentence, and I know the person is just asking questions, so I'm certainly not picking on them, but when they use the language, quote, seller and purchaser agree to escrow $5,000 for post-closing occupancy damages. It is my opinion that that is insufficient. And I believe it's insufficient because there are many questions or situations that can arise, and when applied to this language, it's not clear what is to happen. Anytime you use an addendum or amend language, maybe not anytime, but many times when you amend language, I think an addendum should be used, whether you have a corporate addendum you use, or you're going to write an addendum from scratch, that you need to take the time to make sure that the addendum is explicit, it is clear. And to me, it's easy to understand this because as attorneys, we have the same sort of situation. And that is, I'm living a case. I'm living a lawsuit. It's all in my head. So I write down, 50 words. And when I see those 50 words, I actually am reading 1,000 words because every detail is already in my head. So I read one word, I know the 10 more that go with it. Well, to me, in a real estate transaction, it's the same exact way. You know everything about the transaction because you're living the deal. And so when you write the sentence, you see, literally 500 words, but those aren't 500 words. Those are 8 words or 9 words. And the point being that an addendum should be clear because if there is a dispute, first you're going to look at the addendum. If the dispute continues, you're going to go to court. And a judge is going to read this sentence and say, I don't know what this means the party agreed to. It looks like they agreed to put $5,000 in escrow for post-closing occupancy damages. And of course, the selling agent says, yeah. And, the water heater broke while they were there, and they should have, the seller should have to repair the water heater and or replace it. And the seller says, no, this is damages. And I didn't damage anything. It just broke. Well, I can tell you what happens in court, but first of all, it's gray, but I would tell you that the seller will not pay. Court will not order the seller to pay under those brief facts I just gave. And so if you have an addendum and you make it very clear, are repairs required? Does the house have to be turned over in the same condition it was at the 48-hour walkthrough at the end of the post-closing occupancy? Is there a cap on damages? So when it says 5,000, many courts will read this as a cap on damages. So something happens to the HVAC unit and maybe the seller didn't maintain it, didn't remove a filter, I don't know what, they didn't do something they're supposed to do. And the HVAC contractor who was brought up by the buyer says, yep, the seller should have done this, this, and this. They didn't do it. It looks like they had been doing it, but then somebody just stopped recently. and it's $8,500 for a new unit. And the buyer says, well, okay, so you got to pay it. So it says, no, my exposure is limited to the 5,000. It says right there. Without any additional language, a court is going to say that $5,000 is a cap. Now, maybe that's what was agreed upon. I don't know. But if it wasn't agreed upon, you're going to have a really, really unhappy buyer. Now, in this market, I don't think you're going to get a seller that's going to agree to unlimited exposure in post-closing occupancy. That's probably not realistic. But part of having a detailed addendum is that the seller and the buyer both know exactly what was agreed to. And so when you say to the buyer, look, we should have it, unlimited exposure for the seller if there are damages or repairs during post-closing occupancy. But in this marketplace, that's going to be really tough to get them to do. What number should we say is the cap? And then there might be a negotiation. You say 25,000, the seller says 1,000 and you arrive at 5,000. It's the same 5,000 that says here. The difference is A, you have a very detailed addendum, and two, the buyer understood why you got to 5,000 and doesn't have that question if an $8,500 HVAC replacement has to occur, because they understood you tried to get it to be more, seller wouldn't bite, buyer still wants to buy, 5,000 is the cap. And that's why you want a very, very detailed addendum. So that's my very long-winded answer of saying I would suggest much more expansive language as to what the parties agreed to. Now, I bet if I wrote up an expansive version, a typical realtor would say, well, Rick, all you did was take 1,000 words to say what was said here in 7 words. And that's not necessarily untrue. And if everything goes smoothly, there will be no difference, not a single difference, my version versus this version. But if something goes wrong and you're the selling agent and you have to explain, well, buyer, we would have never got him to agree to a higher cap than 5,000. Well, what is the buyer thinking? Well, you're just saying that to cover yourself. You could have got more. Now, I would say that, no, you never would have gotten more. But when you're in that kind of situation, you're arguing from a position of weakness, at the very least, it's going to leave a bad taste in the buyer's mouth and could turn into a lawsuit against you, that there was some kind of malpractice, that you failed to meet your fiduciary duties to look out for their best interest. Whereas if you went through the expansive version, I'm not suggesting you have to write it, but if you went through that sort of expansive version, well, then there would be no way for a buyer to wiggle out, because as I see from time to time, buyers and sometimes sellers have a memory of convenience. And if it didn't get written down, they seem to remember that they didn't agree to what you said, and you didn't tell them what you said, and I don't remember being advised of that. I don't remember buying a home without an inspection presented any risk to me. My agent said that was perfectly fine, that I should do that, and there was no risk involved. And hence why I think maybe more writing is better.
I like that. And if you guys are using the clauses that are in there to be used, to be placed either onto the purchase agreement under the additional conditions or on an addendum, you'll see that most of those are very thorough and hopefully are answering the what if scenarios. So we'll stay with this, Rick, because there's a question here in the chat that you can see. Should we be providing a lease when a seller has post-closing occupancy? I think I know the answer to that, so I'm just going to let you take that question there.
So, generally speaking, the answer is no. I would not, if I'm a buyer, I do not want to create a landlord-tenant relationship. Can you? I mean, if that's the intent, sure. But Michigan Realtors has had legal opinions provided previously that I concur with, from the late great Greg McClellan, that post-closing occupancy creates it's a term of a fulfillment, or it's a term for the fulfillment of a contract. It does not create a lease in and of itself. And so I would counsel, as a general rule, against a lease unless that's what's intended to be created.
And might I add, Rick, that if financing is involved, typically the mortgage company is going to require that the buyer, the purchaser, take occupancy of the home within 60 days. So any possession past that probably is not going to be allowed if financing is involved.
Absolutely. There are many reasons why I don't think a lease is beneficial. Now, is it beneficial to a seller? Because you say, well, wait, half the time I represent buyers, half the time I represent sellers. From a seller standpoint, I guess I would argue that there's a little more benefit, but not a substantial benefit. You have the right to occupy. It says right there in the contract, you have a fixed term. Your post-closing occupancy should have terms in that govern what is to happen regarding repairs, what is to happen regarding damage, what is to happen regarding capital improvements, what is to happen if a buyer says, well, I want to put a pod in the backyard. Is that okay? And you say as a seller, well, I don't really want that. And the buyer says, well, it doesn't say anywhere in the purchase agreement that I can't do that. So I'm going to do that. And I want to put some stuff in the basement, and I want to put some stuff in the garage, and I want to have some contractors come through the house during the post-closing occupancy to measure for carpet, and painters to give me quotes, and a deck guy to look at the deck, I would argue that if you are a seller and it doesn't specifically state any of those terms, then none of those are enforceable. If you're a buyer, you might think, wait a minute, why wouldn't they let me go in the yard and put a pod there? Why wouldn't they let me bring a landscaper in to look at the yard? I'm not going in the house. Or why wouldn't, fill in the blank? If that's important to a buyer, it needs to be contained in the post-closing occupancy agreement. Without it, there is no right. There are no rights that are afforded the buyer. And you might find a buyer who becomes very, very unhappy thinking, well, why can't I do that? To me, that's something that a real estate professional might raise with their buyer so that the buyer understands what they have or have not agreed to.
Awesome. Now, here's one that's also in the chat room, which, often as brokers, managers, we get approached with the question, hey, is this buyer, is this seller in breach of contract? Of which typically my answer is I don't know. And besides that, it's only an opinion. So we have a specific scenario here where is a seller in breach of contract if the listing agent does not mark the listing as pending, but marks it as CCS, which I think, by the way, for those who don't know, Rick gives his time to be a member of our board of realtors, NOC, and he's serving as a director. So he understands this stuff more than you may know, but CCS, contingent continue to show, which is contingent upon the sale of a home. When you're dealing, I can share with you in real comp, other MLSs may be different, but as stated in the contract, upon the acceptance of the offer. So there's that basic question, is this seller in breach of contract because they did not market properly?
So my answer is, as a technical matter, yes, they're in breach. But courts don't look at breaches all the same way. There is material breach and there is an immaterial breach. So an immaterial breach is something that's insignificant. And I'm not a licensed real estate professional, but in my opinion, this would be an immaterial breach. And an immaterial breach means that the contract remains enforceable. So unless I'm missing something, it would be an immaterial breach. It would be similar to somebody that says, well, our contract says the earnest money deposit has to be deposited, within 24 hours of a successful inspection, and it's deposited 36 hours, 48 hours. The court says, you can bring them to court and you can say it's a breach, and the court will say, yeah, that's a breach, but it's an immaterial breach. And only material breaches act to sever a contract or as an incurable breach of a contract.
So we need to be careful anytime we get a buyer or seller who's going to come to us and say, well, or tell us that this individual is in breach of contract, I'm canceling the agreement. What would you tell us that we should share with that buyer or that seller with that statement?
Well, to me, I would say, look, I understand what you're saying. I get it. I think you're going, I would talk to my broker manager first. That'd be the first person I go to. And depending on if the broker manager can talk to the person, sort of talk them down or give them some context for what they're irritated or irked about. And if that's not sufficient, then I would say you should talk to an attorney. If you don't have one, here's a name or here are a couple names, and let them talk to an attorney. You know, you want to be careful about entering into unauthorized practice of law. And I'm not saying providing an opinion that you don't think it's a breach or it's not a material breach, but you want to be careful because the person that thinks like that is the person that's likely to maybe go one step further. So to me, it's easier if someone else says what you know, which is, come on, this is a nothing. This is a minor breach, if anything. It's barely even a breach. But you saying it, the person says, wait, whose side are you on? Aren't you on my side? And you know, and because I get that as an attorney. And sometimes you want the judge to say it. You're like, nope, we're gonna go to court. Yep, I'm gonna file that motion. I don't necessarily agree, but we're gonna do it. And you can watch the argument, and then the judge does what they do, and you don't have to be the person that's telling your client that they're wrong or that you don't see eye to eye with them. You get another party to say it, and then usually they say, oh, okay.
Yeah. Yep.
That's to me how I would handle it.
Awesome. So this brings up another one, which I think is fairly simple. Kenyana and Jamie, I would say the answer is yes, depending upon the purchase agreement. So as an example, can you mark a pending property pending as accepting backup offers? Well, what does the purchase agreement allow? If the seller has accepted a purchase agreement that says that you will mark it pending and stop all showings, that's what the seller agreed to. And now it doesn't matter what you want to do. You accepted, or the seller accepted the purchase agreement under those terms. And so, Jamie, as far as your question, the listing status, how we have to put those out there, yes, and that's where I kind of cover the aspect of a CCS. With real comp, CCS is contingent, continue to show. But how now does data sharing work, and how does that work when I go over to, say, a home which is listed through the Ann Arbor Board of Realtors? So Rick, would you, anything to add toward that?
No, I mean, you want to follow what your MLS says, but I've never seen anyone make an accusation that there's a breach. So I can't say I have any context for that. That type of breach. I've seen all kinds of allegations of breaches, but I've never seen that type of breach. And even if it said you will mark it pending and you didn't, and they take you to court. Well, if they take you to court, first of all, you're going to fix it. If that's what's supposed to happen in accordance with the terms of the contract, I bet you fix it. And then the court looks at the other side and says, are you kidding me? We're here. They already fixed it. What are you doing? And if you didn't fix it for whatever reason, you say, well, I wasn't sure. So I got to, the lawsuit was filed. So I waited to come here. And then you come there and the court says, well, will you fix it? And you say, if that's what the court tells me to do, the court says, okay, fix it. And that's the end. So these are immaterial breaches. They are not material to the contract, which material just means the important parts of the contract. That is not an important part of a contract. By the way, who decides? The court decides. You can say, who can tell me this, Rick? I want to know right now. Now, there's certain things I can tell you right now but who has the ultimate decision? The court.
And would I be accurate in saying, what does the purchase agreement say?
Absolutely. Yeah, if it's silent, it can't be a breach of any kind. If it doesn't say you can't do it, it can't be a breach.
So that simplifies it. Rick, we've got about 10 minutes left, and I do have two questions that I think are worth addressing. One is the aspect of love letters, and then I'd like to finish up with the aspect of the escalation clause, because we are still dealing with both of those. So from a realtor / attorney perspective, what say you on these love letters?
Well, if I'm a buyer, I might write a love letter because I don't know what a seller will look at or won't look at. And maybe I think I'm a great crafty wordsmith, and I write it. But I think really what the question is about is related to a seller. If I'm a seller, and this is consistent with National Association of Realtors, Michigan Realtors, and that is if I'm a seller, I don't want a love letter. Is it problematic? Not necessarily. I've never seen a lawsuit based on a love letter, some claim made, and the claim would generally be some kind of fair housing claim that you didn't take it because I have 5 children. Someone says, well, that's too many kids. I don't like kids. Or I don't like your religion, or I don't like your ethnicity, or I don't like that you're an unmarried couple, or I don't like that you're LGBTQ. I mean, if you get a love letter, there is a potential for that argument. I'm not suggesting that people that fall into these protected classes are making lawsuits up. I'm not suggesting that at all. But if you are a seller and you don't receive a love letter, and you refuse to receive love letters, then there can never be that accusation. It can't factor into your decision making. Some people are biased. That happens. But if you don't get a letter, then it can't happen. And generally, as a seller, you're looking at price and terms. Who's got the best combination? Not necessarily the highest price, not necessarily the best terms, but the best combination. And the fact that it's an individual or a giant family or something else is generally speaking, not generally speaking, in my opinion, it's never relevant. It has nothing to do with the transaction. And so not receiving love letters, and as a listing agent, not accepting love letters, just rejecting them, sending them back, not opening them. I'm going to guess that's in your policies and procedures in writing. And if it's not in writing, I bet it's been said that way. And so my opinion is you don't want anything to do with love letters. You want to discourage love letters. And the selling agent says, but no, my clients really want the house. And I think this comes right off of NAR. It says, well, then how about a bigger deposit? How about an escalation clause? How about an appraisal guarantee? How about, a shorter inspection? All the things that are measurables when evaluating an offer rather than, some love letter. And I'm not trying to make light of people doing that, but that's not, and really, in my opinion, shouldn't be a factor in making a determination as to what offer is or is not acceptable.
So you know what? This is a great question. And I have had it come to me time and time again as a manager and broker. So we've got to hit it. Wrote an offer on a property in Silverwood, Michigan about 3 weeks ago, got no response from the listing agent. Followed up and the listing agent said the offer was too low. They rewrote it for a higher price. Called the agent, said that they'll send me a counter offer, and still I've got nothing. As a buyer's agent, what can I do with a listing agent who's communicating with me in this direction?
So the listing agent has to present all offers unless they've received instruction otherwise. In other words, if they say, hey, any offer that's VA financing, any offer that's below 200,000, any offer that is contingent on the buyer selling their own home, a seller can make blanket statements like that. Now that it seems to be relatively unusual, but they can do that. Outside of those parameters being set by a seller, the listing agent is duty bound to present all offers, period. They must present it. If you think that your offers are not being presented because you say, well, I'm not getting a response. And I've had some people say, well, I'm not getting an adequate response. They're telling me it was rejected, but I want more than that. You have to write it up. You have to explain to me. There are no rules that say you have to explain to me in detail. But if you think if your offers aren't being shown, or you're getting communication that makes you at least suspicious of that, go to the broker. Now, I would go to my own broker manager first to have broker to broker or manager to manager to do that. And typically, at least in my experience, that will resolve it because you will get a more succinct response. And if somehow the offer isn't being shown, I bet it gets shown. But that is how I typically would suggest handling it. And I have not seen anything go beyond that. I don't know if other people have, but I get this comment frequently from selling agents say, I don't think my offer is being presented. I don't think they're showing it. Or I think they're showing it, but they're saying you shouldn't accept it. Well, that could happen. And a listing broker gives their opinion. I don't think this offer is good enough. I think we should hold out for something better. that could happen. There's nothing wrong with that, even though it might be very frustrating, especially in these very competitive situations. I'm sure there are many times that offers go unresponded to, and you are with your client's anxious, wants to know, and you're not getting any feedback. And again, that's when I go to my broker manager to have broker to broker discussions.
And I would tell you the best thing that you could tell anyone is to treat the offer as if it's been rejected. Because it's the only thing that you know. If there's nothing coming through, you have to treat it somehow. Obviously, it's not been accepted. You don't have anything with that. And Rick, I want to keep going because a quick answer. Can we give a quick answer to what's the estimated cost of setting up a trust?
So we charge $1,500 for a trust. It's on the lower end. I think you'll see that's about as low as I've seen, and you maybe see up to $3,000. And then if there are some estate planning attorneys who have a very sophisticated clientele, in which case you could see it go up to $10,000, but that would be unusual. I would say 1,500, maybe 1,250. I haven't seen that recently, but 1,500 to 3,000, I would say, is the price range that I've seen.
Good. And this is such a great question because it's another one that I've run into time and time again, John. So thank you for throwing it out. We know that contracts basically have the language that says, I'm unsatisfied, I'm dissatisfied with the inspection. And it will be a mutual release that both parties will sign. And then you get a seller who wants or thinks that by not signing the mutual release that's actually going to make a difference on something. So as you can see there, what do you do in a situation where a seller won't comply?
So a couple things. In fact, this came up recently. I was at a golf outing for the industry, a Women's Council Realtors, and I happened to be with a broker, and over the course of 18 holes, this issue came up, and he said, well, we write in our contract that says that unless the other party, specifically the seller, makes a written request for the earnest money deposit, that we automatically release it to the buyer. I will tell you that violates license law. I have gone to Laura for an administrative hearing. We don't have time to go into the facts, but it was a tearjerker, a real tearjerker, as to why my buyer, by the buyer broker, selling broker, excuse me, why they released the money without a mutual release. And I can tell you that Laura still fined them. It was a minimal fine, but it was still a fine. The point being that as a broker holding escrowed funds, you cannot release it without a court order or mutual written instructions, period. So what do? Well, unfortunately, you're stuck. I mean, this assumes you've gone to the other agent. The other agent oftentimes is in agreement, say, I know I'd like my client to release it. I've talked to him about it, but my client won't release it. You could go to your broker, but typically if you have, I shouldn't say typically, it doesn't happen that often, but when it happens, you've got a seller that's just hell-bent on, I'm not going to sign a mutual release. At that point, the buyer's only left with court. That is the only way to get the earnest money deposit back at that point. And court will not award legal fees. And so if you're talking about a deposit of $1,000 or $3,000, you're going to spend more than that going to court. You're better to split it. Now, you might get a seller that says, no, I'm not splitting. I'm not getting, it's all mine. Then you're stuck. You go to court. And if you don't go to court, then eventually it will escheat to the state. That happens if there's 3 years passes with nobody making a claim to it. Now you could keep renewing your claim, and then it just sits in your escrow account. We see a fair amount of brokers starting to add fees so that if it stays in their account, because they have to account for it, and it's kind of a pain in the butt, that after, let's say 6 months, if the money's still there, that, $50 a quarter is taken out, and eventually it will eat up the entire EMD. That's not because the broker wants that EMD. They don't want any part of it. They want it to be gone, but that is sometimes a way to sort of prime the pump to get the parties to do something. It would be inappropriate for a buyer to file a claim of interest, which I've had some people say, well, I'm going to file a claim of interest because they won't give me the EMD back. A claim of interest is claiming an interest in a property if you are claiming an earnest money deposit, you are making a contractual claim. You're making no claim to the property. In fact, you've already said, I don't want the property. So you're literally stuck with court. The seller can sell the property on once a buyer repudiates and says, I'm not buying. Or a buyer's in default and they haven't cured the default. The seller doesn't need a mutual release to sell the property to buyer number two. Now, that doesn't mean getting a mutual release isn't a great idea for buyer and seller. It's very helpful. Why? Because it's very clear. It doesn't lend itself to any argument or future revisionist history because it's signed and says what it says. But it is not required by the seller to sell on. So the seller can sell to buyer number two and the earnest money deposit sits there. Or buyer one could file a court action and the buyer and seller are in court over the earnest money deposit. In the meantime, property is being marketed and sold to buyer number two because they're independent of each other. The earnest money deposit at that point is just a contractual claim. It has nothing to do with the sale of the real property, which is why the seller is allowed to sell on. Now, some title companies will act as gatekeepers and say, no, we're not going to write title insurance for it. There's this dispute. And the seller says, and their attorney says, yeah, but you don't understand, the dispute's about the contract. I mean, it's not about the real estate. And some title companies will say, yeah, we don't care. We're not writing title for it. You got to resolve it. And that's not an unusual position, by the way. I don't know about your title company, but it's not an uncommon position to be taken. And what I would say to a seller is, if you're entitled to that money, I get it. You want to go to court, no problem. And sometimes they're very significant deposits. We've had deposits of up to $200,000 on residential property. Not common, but we've seen it. But if you go to court, and we've gone many times, if you can't prove in clear and convincing evidence that you, as the seller, are entitled because the buyer is defaulted, the court is giving it back to the buyer every time. You know, the old baseball term, the tie goes to the runner. Well, if it's gray in any way, if it's not black and white, the court always awards the money back to the buyer with the thought that, hey, seller, you still have the asset, you get to sell it, you'll make money, it's buyer's money, and they're just getting a return of their money, and that's the way I'm going to resolve it. So holding a buyer up, unless you're really confident that you're in the right, and it happens, of course, but if you're just doing it to be a jerk or you're not sure, you're generally just wasting your own energy.
So guys, if you run into this, get with your broker manager. Talk to them about the situation. We have a little process we've established that helps us in regards to the release. So yes, it could be stated in the exclusive right to sell. It could be put in the buyer representation agreement. It could be and is in the purchase agreement what will happen. But it doesn't mean that the parties are going to cooperate. And it may mean that it has to go to the courts. So what we're trying to do is to make it as clear as possible for a judge to be able to take a look at something and go, okay, here's what will happen according to the terms of the agreement that the two parties actually had a contractual agreement to. So, well, Rick, we've now kept you 4.5 minutes overtime.
Hey, Darwin, can I ask
go-
Rick one last question?
Sure.
Just about the love letters, do we have to present those to our sellers?
No. No, in fact, and to me, I'm glad you brought that up, Tegan. I would ask my seller client and I'd counsel them why you think that a seller doesn't want to receive it. And the seller generally is going to say, yeah, I don't want that. And that way it's confirmed. But I wouldn't want to accept them in any way. I don't want them in my hand. I don't want them emailed to me. I don't want them sent to my office. I don't want them. But a nice way to do it to me is to sort of educate your seller so that they don't, they're not out at some local function and there's a neighbor that really wants the house. And so I sent you a love letter. Didn't you see? My little Susie is going to be in first grade next year and Timmy's going to be in fifth and this house would be great in the backyard and blah. And the seller comes to you and says, why the heck didn't you show me that? I mean, I would have loved to sell to them. So if you counsel them in advance, of course, then that eliminates that issue.
Awesome. All right, guys, we'll want to be respectful of everyone's time and especially Mr. Rick Linnell. The best way that you can say thank you for his time today is when you do have any issues, when you have any concerns, know that he and his firm do take care of real estate issues. And I think that's the thing. There's a specialization in regards to real estate law where these guys are in it every day and have the experience to be able to address it. So, Rick, thank you again as always. Thank you for giving your time to our associations and everyone else. We are working on getting these things back up and posted into the HRC agent development so that you're able to go back. Guys, there's a boatload of information and education in there. Check it all out. Subscribe to the channel. That way you'll know when anything new has been added. So Rick, thank you again. Greatly appreciated. You are awesome.
Thanks, everyone. I appreciate it, Darwin.